So I think the courts as a whole, and particularly the Constitutional Court, has made strides. I saw a need then, early in my legal career, to make sure that women are briefed more widely and that there is really transformation for women in the legal sphere, women lawyers. Courts can't parachute into the morale and morality of society. So there has to be a big push into the values, and that must come from society itself. I was amazed how these American authors are looking at South African judgments. They're looking at the concept of Ubuntu,
Yes.
Which is very close to my heart.
Thank you for making the time to sit with us today. As I mentioned earlier, the African Lawmakers blog is reflecting on 30 years of democracy in South Africa. We're looking particularly at the role of the courts. And I think you're the ideal person to sit with on this because you have a lot of experience really within the legal landscape in South Africa. And I'd like to start by reading something that I found when I was preparing for this interview. It's a bio of yours from the JSC interviews in 2016. And this was when you were still starting out and you were still a Gauteng High Court judge at the time. And it reads, Gauteng High Court Judge Margie Victor has tread a groundbreaking path through the legal fraternity, smashing glass ceilings, egos, and presumptions of white male superiority where she can. Is that an ideal description of you, just to start off, for those who don't know you?
Yes, I think it's accurate. I think it reflects my passion for the law, my passion for transformative constitutionalism, and really to look at every aspect, every problem that is encountered, every case that comes before you as a judge, and then to deal with it. And even when I was at the Johannesburg Bar for 25 years, I looked very closely at racial transformation, gender transformation. So that's really been my passion throughout my legal career.
Absolutely. So I just want to take you back through your amazing judicial career. You started off as a member of many different courts. We spoke about the High Court. You've been a member of the Competition Appeal Court, the Supreme Court of Appeal, and this court, the Constitutional Court. With this in mind, I would like to hear your views on how the role and significance of courts has evolved over the past 30 years.
Yes, a very important and interesting question. We are light years away from the pre-democracy era. There, the judges simply implemented the law. They imposed the black letter of the law. They had their loyalty and fealty to the law without looking widely. Except there came a time when, for example, some of the more liberal judges, like Justice Goldstone, took a look at the law and then interpreted in terms of what was just and equitable. And that was light years away, it would seem. If you look now, 30 years later, there has been exceptional and deep-rooted development in the law, with clearly the Constitution being the North Star in everything that a court looks at. So one can only look at the evolution of the different cases, the implementation of the law, and say that there has been exceptional constitutional transformation in all the cases that come before the court. If you think of the previous death sentence, one of the first cases that came, Makonyane, and look where we are now, the right to love, the right to health, prisoners having the right to vote, now multi-party political parties, gender issues, the rights of sex workers.
Reproductive rights.
The reproductive rights. So we light years away from where we were 30 years ago.
Absolutely. And then just as a follow-up question, would you say, the Constitution has succeeded or failed in achieving its purpose as a supreme protector of democracy and human rights?
I would say that the Constitution has substantially succeeded. There are still gaps, and these gaps really relate to a lack of resources. For example, in health, housing, and environmental law matters. You know, the Constitution is really the North Star and has opened the way to proper interpretation and implementation of human rights. But no matter how keenly the Constitution and accurately the Constitution is interpreted, if there are not enough resources, particularly in socioeconomic right matters like housing, other economic rights. So I think the courts as a whole, and particularly the Constitutional Court, has made strides, and it's only hampered by the lack of resources. Because the Constitution is supreme. Every judgment that a judge does has to take into account the supremacy of the law of South Africa being the Constitution.
Absolutely. And you know, that has me thinking a lot about the dialogue. So just as a follow-up question to that, I know this is not on the list, but just the relationship that is supposed to be there between the executive and the judiciary, because in most cases it is the executive that is responsible for carrying out the decisions of the court. Are we seeing an evolution of dialogue between those two branches?
Yes, I think to a large extent. There may be more dialogue. Certainly that would be encouraged. But I think that where we are 30 years later, there is a more positive interaction between the executive and the judiciary, bearing in mind that we're two separate arms of government. So I think it's important the judges are in fact directing the discourse, because with democracy comes responsibilities.
Absolutely.
And while one can leave it to the politicians and the executive to direct that discourse, I think that the implementation of some of the judgments that the courts are giving, that is directing the discourse into equality, human rights. And I don't see any dissonance between what the courts are ruling and the executive carrying out those rulings to the best that they can.
Absolutely. Now, I'd like to kind of move to, you know, your passion for gender equality. This is something that has been evident throughout your entire career, how committed you are to mentoring younger female lawyers and bringing about gender transformation within the legal landscape. You've been involved in the International Association of Women Judges and the Woza Women's Academy of Learning project. And my question would be, with all that wealth of experience, do you see a realization of women's rights over the past 30 years? And in your view, how can these rights be protected better in the future?
An interesting question, because you know, women, the Constitution, of course, in Section 9.3 does provide for equality. But there are some instances where one doesn't only look at gender equality, one must look at the wider context. And for example, in one of the cases I've done is that of Sylvia Mahlangu, who was a domestic worker, and she worked with this family for 22 years, and of a day she was cleaning windows next to the swimming pool. Her eyesight wasn't very good and she overbalanced and she fell into the swimming pool and died. And there was no compensation for her or any other domestic worker that was injured on duty. So when one looked at the statute, that statute, COIDA, it's abbreviation, really provided for compensation for workers who are injured on duty or die on duty, except, that statute said except for domestic workers. Now, looking at the impact that that has in South Africa and many other countries where there are migrant workers, the effect on domestic workers was far worse. So one looks at the context of intersectionality. who is a domestic worker. In this country, it's mainly a black woman who is who contributes to her family. So if she's injured or dies on duty, her family are left without any form of support. So that was really the pinnacle of all my years of trying to contribute to the feminist doctrine of gender equality. But it started a long time ago when I first went to the Johannesburg bar. Women advocates only did family law matters. And of course that has changed, but not enough. So I saw a need then, early in my legal career, to make sure that women are briefed more widely and that there is really transformation for women in the legal sphere, women lawyers. And then, of course, that impacts on women in the community. So my passion there was to make sure that not only women lawyers, that their progress is promoted, but also women in communities. I'll give you an example. There was one case where a small community lived outside of a steel mill, and the women were feeling the brunt of living in that polluted area. Their children were suffering from chest problems. They themselves had problems. They couldn't plant because the groundwater was polluted. So that was another element that I saw, the need to really make sure that gender equality is implemented in its true sense, in its wider sense. One can't only say, well, there's equality for women. One's got to look wider, one's got to look at the context and say, is there real equality and how do we achieve it? And one of the legal tools is looking at the intersectional effect on women of a class, of a race, etc. And this is the theory of intersectionality is of course based on an American professor when she wrote on black feminism, Kimberly Crenshaw. And I was fortunate enough to adopt that in the Mahlangu case. And there was full consensus on the theory of intersectionality. You know, it's not only on gender, but children. One's got to look and see what is the intersectional effect that a particular school policy has on children. And I suppose intersectionality also applies to males, like one of the cases I did where a male was, a South African man was married to a Congolese woman, and he wasn't allowed to register his child's surname in his name because the parties weren't legally married. So, you know, so I did that intersectional analysis. And, you know, men too can suffer from discrimination based on a lack of this intersectional analysis. So, and then of course you've mentioned mentoring of women. So not only when I was an advocate did I make an effort to mentor women and to make sure that they get good cases, and not only the family law cases, which are very important, but there was a particular stereotype. If it's a family law matter, give it to a woman advocate. So those were the early days. And then I did a lot of pro amico work for women victims and women who couldn't afford legal representation. And, you know, we put together a group of women to attend to that. And then, of course, when I got to the bench, I realized that, you know, we've got to do more to make sure that more women can enter the judiciary. And that's when I did a lot of mentoring of young women lawyers. Also males, but the focus was on women lawyers. And then when they do get to the bench, you know, one needs that network where a woman judge can feel safe
and supported.
And supported. And I must say, you know, certainly in our bench, there is a lot of support for young judges entering the bench.
Would you say there's more representation now
Oh
compared to when you
yes,
started?
a lot more.
Absolutely.
And there's, if you take, for example, our judge president of the Gauteng area, I mean, he has appointed an enormous number of women to the bench. And so, you know, one knows that the legal profession is moving towards gender equality on the bench, but there is still that need for women in the profession to make sure that they don't leave the profession early because they just don't get the briefs and the skewed briefing patterns. So let's say after 30 years, there still hasn't been enough attention given to women legal practitioners. And, you know, there are NGOs and various groups that are working on that. Including with international organizations such as the Cyrus Vance Institute, the Atlantic Council, and so on. So there's an international focus on seeing how women transition from the profession to the leadership.
Amazing.
And, you know, finally, after 30 years, we have a female Chief Justice.
That's amazing, yes.
We have a female Minister of Justice, or I must say at the dawn of democracy, we had Minister Bridget Mabantla. She was a woman Minister of Justice. And she did a lot to encourage women and empower them to move into leadership positions. But it's taken a long time.
It has, yeah. But I think we're getting there.
We're getting there, yes.
You know, I just want to go back to the Mahlangu judgment because I am a big fan of that judgment. And, you know, it has set such an amazing precedent for similar cases. We're seeing the principle of intersectionality showing up in other judgments. So I just want to commend you for what you did for us there. It's amazing how that is filtering through to lower courts as well, in rape cases, GBV cases. Yes. And speaking of which, I don't think we can talk about gender equality without talking about gender-based violence, especially in our country. So I have a question about that. You know, what are the present, you know, significant challenges that South Africa is facing with regard to GBV? What would we say are the root causes? And how can the courts contribute to addressing these pervasive issues?
Yes, it's a very important question. Of course, let me just start at the court side. You know, courts can only adjudicate on the facts that put before them. And we know that the National Prosecuting Authority is under enormous pressure and also the investigations. But I must say there's been massive improvement. So, you know, the courts, and there have been some very important judgments like State versus Shabalala, looking at it is not only the rape itself, but society as a whole and the environment. So it's not only the rape, it's the dignity of the woman, it's the safety of the woman. And I think the courts are addressing that larger issue. But let me say this, courts can't parachute into the morale and morality of society. So there has to be a big push from into the values, and that must come from society itself. But I do believe that our judgments provide guidance, a North Star that society, the communities can aspire to. But of course the rate is far too high. And in 2018, when I was the vice president of the South African chapter of the International Association of Women Judges, you know, we were adjudicating terrible cases, violence against women, rape, etc., murder against children. And we thought, well, where could we start? What could we do outside of our judicial role? And we then flighted a program for learners. That was in 2019. And we went to Tembusa High School. There were 3,000 learners. We were supported in this by the then Minister of Education of Gauteng, Mr. Panyazi Lesufi. And we used that American theater forum method, where in South America, the priest Augusto Boal, he devised a method of theater where the oppressed were taught to deal with the oppressor. And we used that theater with the Market Theatre here in Johannesburg And we tried this that was a pilot project where learners were given the tools to empower themselves to deal with grooming, the need to report. And then unfortunately COVID intervened. But now that same program has been taken up by the Department of Education. And so, you know, there are a lot of people looking at sexual and gender-based violence and how it can be addressed. So it's a collective effort. And of course, that was in 2019, 2020. We're now in 2024, and we're faced with a massive problem of AI, social media, and the power of social media. You know, where a learner's face can be taken and then a different body put on her. So, you know, that is there are NGOs addressing that, where there has to be ongoing input for young people in that social media sphere, which is critical to them, as we know. Virtually, you know, people have smartphones, etc. So, you know, one's got to look at that and say, maybe this can be a tool to empower young people to deal with bullying. And we think of all the suicide that results from bullying on cyberbullying. It's a worldwide problem, but I do believe that it can be dealt with at that level. But it's ongoing, because you've also got to address males to do that. And for that, you need male allies to say, we're going to assist with this project. And so there are NGOs dealing with that.
So one of the things that stand out to me, just as a follow-up to what you were saying, you know, is that, you know, the courts can only do so much. There's a societal problem that we have. And one of the things I think of when I read GBV cases sometimes, that judges are human, and sometimes their biases flow into their judgments. So I'm wondering, what can we do, or how can the courts evolve to an extent that, you know, even the language that is used in the courts is more victim-centered, because sometimes victims are being re-victimized in the courts, especially the lower courts, if I may say, right? So it starts from the reporting process, the attitude victims are receiving from police officers when they go to report these crimes. Then you go up to the courts, some of the language being used by magistrates, especially around consent, right? There was just a case that came out recently surrounding the language of consent and what tacit consent is, and if tacit consent is even a thing. How are we evolving in that regard, in regard of the language that should be used in our statutes and the courts?
Yes, I think the attempts to conscientize judicial officers, and I think that's an ongoing program, but it's a very important program. And I think even before one becomes a magistrate or judge, one's got to be questioned very carefully at the interview, and to see that the people are sensitive to the correct language. Because there's just so much secondary trauma that happens when a victim reports initially and then comes to court. And think about child rape victims. There is so much sensitivity that needs to be implemented and really part of our norms within the judicial precinct. So I think that that's an ongoing battle. It's got to be given a lot of attention at the highest level. And there is the national strategy that the President has promulgated, that program to address sexual and gender-based violence in South Africa. But it's the question of implementation. It's got to be implemented at every level. Because, as I said, you know, the judiciary can't parachute into the hearts and minds of the community. We can only provide guidelines, but it's at the community level that there has to be change as well.
But there have been strides, yes. We've done away with marital rape, we're changing the definition of consent, the SOMA was revised.
Yes.
So there are steps in the right direction. Yeah.
And one must bear in mind that we are addressing it, and perhaps more so than many other countries in the world. We're just not taking it for granted that it's going to come right. We're actually addressing it.
Absolutely. So another thing, just to shift away from, GBV, in recent years we've seen the courts, and particularly the Constitutional Court, being called upon to deal with high-profile, politically loaded cases. What are your views on the implications of this for South Africa's democracy and the role that the Constitutional Court has to play?
Yes, I think one's got to be careful of it becoming a situation where there's lawfare, like a war. I don't think that there should be any dissonance between the courts and the outcomes of some of the political cases. We know that many high-profile political cases have come to the courts and are still coming to the courts. But I don't believe that there has to be dissonance or a war, so to speak. With the Constitution as our North Star and what we want to achieve, with constitutional transformation, these political cases and the court should see, well, the Constitution is the North Star, so there shouldn't be this dissonance. Sometimes it is tough for politicians to accept, the outcomes of the decisions. But at the end of the day, the three arms of government have to be in balance. And if a decision comes from a court which is adverse to the politician, it's got to be accepted. It's just law and order. Otherwise, it's going to become chaotic if the court's decisions aren't implemented. And bear in mind that when a court listens to a case, they listen to both sides.
Yes.
And particularly, when it gets to the highest court, the apex court, this constitutional court, the issues have been traversed from the lower courts all the way up. And the politicians have to accept the outcome because this is the end of the road. But as I said, and just repeat again, there doesn't have to be dissonance. With the Constitution as the North Star, there doesn't have to be dissonance.
What I do think of with such cases, and I just want to hear your view on this, is when I think of the implications on democracy, for example, when a politician comes to a court and they lose the court, they then go back out into the public and start criticizing the court. And is that maybe impacting on the faith that the public has on courts? Because politicians are very influential. And sometimes you then hear, no, the Constitutional Court is captured. That's the general assertion or allegations of judicial activism.
Yes.
So how do we manage the implications of such cases in our
Yes,
democracy?
and I think that the courts have got to be very sensitive to those criticisms. But, there has to be objectivity. If every decision or many decisions that emanate from a court result in criticism, well, that criticism is there. When it's in the lower courts, there's a lot to ultimately when it gets to the Constitutional Court, these criticisms will be heard. But, politicians have to realize that with democracy comes an obligation to steer the discourse into an objective direction. So when a court makes an adverse ruling, democracy requires that the discourse on that ruling be dealt with in a positive and educational way. So one's got to make sure that the courts don't lose their standing or their reputation amongst the public. But, you've got the benchmark of the Constitution. And so, it requires moderate language, but it doesn't mean that courts can't be criticized. But it does require moderate language, and it's very difficult for a politician when they're absolutely passionate about what they're doing. But they must remember that with democracy comes the obligation to steer the discourse in the right direction, and in the direction of being in favor of the people.
I think there's a delicate balance to strike there, because I remember, for example, and Justice Majid pointed this out, when one of the Zuma judgments was released and there were riots in KZN in response to an order to arrest former President Zuma. So that balance is a very tricky one to strike.
And then, sorry, just to
yeah,
continue on
yes.
that, if one looks at the very outstanding and bold judgment of Justice Kampepe, I mean, the courts have to be fearless. And she
Yes.
expressed that objectivity and fearlessness. And, the rule of law is really so important. So if there is a riot and some discontent, one's got to say, well, what does the rule of law require in these circumstances?
Everyone has to be equal before the law.
Yes, yes. No one is above the
The law,
law.
no one is above the law. That is correct. So, considering global trends and contemporary debates surrounding constitutionalism and democracy, what lessons can be drawn from South Africa's experience over the past 30 years?
Well, I think that a lot of countries and in progressing their jurisprudence have looked at some of our judgments, which is very encouraging. I think that even the International Court of Justice has also looked at some of our judgments. So there is a sensitivity to what is emerging from our very progressive constitution. For example, I'll give you, well, there are two American authors that have written about some of my judgments. They are Chris Franklin and Sarah Chin, and I was amazed how these American authors are looking at South African judgments. They're looking at the concept of Ubuntu,
Yes.
which is very close to my heart. And this is what they said. They said that nonetheless, Judge Margaret Victor's constitutional jurisprudential challenges us to expand beyond a narrow mode of fealty to text over context. And then they go on to say that you must look at what the South African jurisprudence is showing is that you must look wider and deeper and not just at the laws themselves. So, one's looking at it. There is one area that perhaps I should mention that we need to look at more carefully in South Africa from a constitutional perspective, and that is contractual sophistication. People are entering into contracts, give you an example, in the insurance industry, and English may be their third language, and they're taking out life policies and accident policies and not knowing the difference. So I think that we have to, that's perhaps something after 30 years of democracy, we've got to look at the concept of Ubuntu in contractual law and also contractual sophistication. And the Americans started addressing this in about 10 years ago, looking at contracts, complex commercial contracts, because let's face it, the world is moving in, and South Africa is certainly moving into these contractual realms. And, a signatory to a contract, should it be in their mother tongue, or should it be explained to them in their mother tongue? So that's an area that is being looked at globally by some jurisdictions, and of course something that we need to expand on, looking at contractual implementation and also Ubuntu in contractual matters. And in one of the cases, Bidika, which involved a franchise, there the concept of Ubuntu was discussed and the importance of Ubuntu. And there were three judgments emanated in the case of Bidika. And there, it was accepted that Ubuntu is a foundational jurisprudent a value in our jurisprudence. So we mustn't leave our African roots in whatever we do. So much of the South African law has been based on the Roman Dutch law. Meantime, centuries before those 1600s, Ubuntu was a foundational value in Africa, and we have to see that it remains. And, starting from the very first case, Ubuntu has been accepted, but it's now firmly entrenched by the apex courts that Ubuntu is something that really is an important consideration in adjudication.
Amazing. I really find that fascinating because I've always thought of Ubuntu as a human rights value for maybe civil and political rights or just within the public law realm. I've never thought of it in a commercial law sense. So I find that very interesting. Thank you
Yes.
for that. And I'm just wondering, just to follow up on that, do you feel that the role of African law norms in general has evolved? Is it only Ubuntu? Are we seeing more African law norms featuring in judgments?
Well, I would like to see more of it. If one thinks of the case involving customary law and primogeniture,
Yes.
where the first wife lost out.
Bear,
And,
yeah.
you know, that is where the courts didn't implement customary law. But there are lots of other areas where I feel customary law can be recognized more widely. And you know, if you think of Muslim marriages, etc. So there's still a gap in that area where customary law can play a greater role. You know, perhaps even a greater role in mediation, conciliation. If you think of days gone by, I grew up in a very remote valley in the Eastern Cape, where the leaders would get together and have an imbizo, you know, a meeting, and problems would be discussed, debated, and maybe, and I think the courts are looking at this. In fact, if you look at the Uniform Court Rule 41A, cases should be mediated before they go to trial. And so that mediation process, I think, stems from our customary law of mediating a dispute rather than, you know, just giving a judgment. So you'll find in many matters in courts, the judges do ask, can this matter not be settled? So I think there is a greater role for customary law.
Is it a matter of we're not getting enough cases before the court dealing with it, or
Yes,
judges
yes.
should? Yeah.
It's very difficult for a judge just to pronounce on principles and facts that are not before the
them,
court.
yes.
So I think that civil society has to do a lot more to make sure that these issues are brought to court and that they are traversed in court cases.
That's very fascinating. Lastly, Judge Margaret, I just wanted to ask, you know, we spoke about you shattering glass ceilings, and we can't speak about that without mentioning that you were the first woman to be elected to the Johannesburg Bar Council. And I just want to know, with that experience and how far you have come in your legal career, what advice do you have for young people who care about the future of South Africa's democracy?
Well, what I'd like to say is, you know, one must never give up. Young people have dreams. Maybe a young lawyer, a woman lawyer, has a dream to become the Chief Justice of South Africa. So never give up on dreams. If you think about it, a drop of water can become a wave and then can become a tsunami. And that's how it started. When I was first elected to the bar, I was elected to the Bar Council by my peers. And you know what role I had? I was the tea convener.
Wow.
And you know what I did? I said, that's fine, but I'll show you. I'll see where this leads.
Yeah.
And I was privileged to do, we had the first black Chief Justice, Mohammed. And I arranged a gala dinner to celebrate his inauguration. And I invited Chief Justices from all over the world to attend that gala dinner, and it was magnificent.
Wow.
So from becoming a tea convener, it changed into something else. And this is what young people must realize, is that, you know, they can start off humbly, but they can then expand exponentially in their careers. And also to young lawyers, one's got to look at AI and the influence of social media and to use it wisely and to make sure that one empowers other young people to use it wisely. Because if you look at AI can easily push us into a biased direction. And young people, you know, really have the opportunity to mold the future of the world, really. and certainly in South Africa, that mold the future of our jurisprudence. So I say dream and never give up.
Amazing.
You may be knocked back, but you just get up again and you continue.
What does the next 30 years of democracy in South Africa look like to you, ideally?
Well, ideally would of course be gender equality, both in the legal profession and of course in South Africa, for women in South Africa, women and environmental law, women and climate change, that there's gender equality there because women are bearing the brunt of climate change, not in South Africa. And then the dream for looking at Africa, a Pan-Africanist approach to law, to gender equality. And there is an NGO, the Institute of African Women Lawyers. I'm a director of that organization. And looking at women on the continent and seeing, you know, what can be done to improve their condition and their promotion. And then, of course, we must look internationally. One thinks of the women in Afghanistan. Look at the women judges. 2 of them were murdered. Others had to flee. So, you know, the next 30 years, I see as important having this international outlook. Think of it, girls in Afghanistan can't go to school. Only boys can go to school. Look at the intergenerational effect of that. Boys will be schooled and socialized and conscientized into believing that women cannot succeed. So one looks nationally, one looks at the continent, at the Pan-African approach, and then internationally. So the challenges for the young people in South Africa and the world over are enormous. It's a more complex world, I think, than we faced.
Absolutely. But you know what? You have set such an amazing trajectory for those of us who are still in the legal landscape, and for that, we'd like to thank you for the glass ceilings that you shattered for us. Thank you so much for the amazing jurisprudence you made as well.
Thank you.
Thank you for taking the time to sit with us. It's been a pleasure.